always great to talk to you.
Pleasure to be with you, Ginny.
Federal Judge Samuel Cummings has dismissed the NRA's case challenging the age limit restrictions in the current law that bans people under the age of 21 from buying a handgun. Were you surprised by the judge's decision?
We were surprised, Ginny. Judge Cummings, we have the utmost respect for him. He's been a real stalwart and champion of Second Amendment rights in his prior writings and jurisprudence, but his decision in this case really rests on two propositions which we think are erroneous. First, he seemed to acknowledge that 18, 19, and 20-year-olds have a right to possess a handgun, but then he said they didn't have a right to buy a handgun, at least from a federally licensed dealer. And we don't think you can disaggregate those rights, that if individuals have a right to possess a gun, then they necessarily have a right to buy a gun. Otherwise, it's a meaningless and empty right. So that's the first premise we think is false. The second premise that he adopted was he compared 18 and 19 and 20-year-olds to infants, or as that term was understood at the time of the founding. And at the time of the founding, 18, 19, and 20-year-olds had a right to keep and bear arms. In fact, if you were a male, you were required to be in the militia. So we think that premise of his analysis is faulty, too. And we very much like our chances on appeal. We plan to appeal next week. We will do that, and we like our odds in the Court of Appeals.
Yeah, I mean, when you look at the judge saying that he's comparing 20-year-olds to infants. I mean, 20-year-olds, they drive, they can vote, they drink.
And they can fight in wars.
Yep, they're in the military, absolutely.
Exactly, and that was true back at the time of the founding. The age of being in the militia was 17. So you had 17, 18, 19, and 20-year-olds all serving in critical functions in the military. They were required, if they were male, to keep and bear arms, and females certainly had that right as well at the time of the founding. So we were very disappointed that he didn't agree with us on that, but again, we're confident on our position ultimately prevailing.
And the judge also said that this issue is really for Congress, not the courts.
Well, I think that's wrong. When you're talking about a fundamental constitutional right, that's why we have courts. That's why the Supreme Court intervened in the Heller decision and the McDonald decision and ruled in favor of the NRA's position, was because the court recognized this is exactly why we need courts. So when you're dealing with fundamental rights, that's the quintessential example of when we need federal judges to step in and tell Congress they can't take away our rights.
No, and you've got some pretty strong plaintiffs in this case.
Oh, we do indeed. Rebecca Jennings is a decorated, competitive shooter. She has 7 national records to her credit, and so we and the other plaintiffs are very solid citizens as well. And so the notion that a woman like Rebecca Jennings, who's handled firearms for thousands of hours and is incredibly accomplished, she can't go into her local Walmart and buy a handgun is really ridiculous. It
is, and a college student who plans to live off campus and makes very clear she wants to buy a gun for her personal protection.
Absolutely. And, the other thing that the ruling did not address was our, we thought, very compelling argument that this is an irrational regime. It does permit these young adults to buy handguns, but only if they go into the unregulated secondary market, which severely limits the quantity and quality of selection that they can get. Some of our plaintiffs don't live anywhere near a federally, don't have an opportunity to really have a meaningful secondary market. There aren't gun shows that come near their home. And so when you tell these young adults you can't go to a federally licensed dealer, you're really telling them you can't buy a gun at all.
Yeah, and it's their right. They're 20. I mean, you're talking about 18, 20-year-olds.
Right, and they're paying taxes,
yep,
and they're eligible to serve in the military. They
Absolutely.
Can vote,
yeah.
and this would be the only fundamental right that would not be extended to people in this age group. And that's one of the teachings of the Supreme Court in Heller and McDonald, is that Second Amendment rights can't be relegated.
Yeah.
It's not a second-class fundamental right. It applies as robustly as the First Amendment and all the other provisions of the Bill of Rights. And that's true for all adults, including adults in this age group.
So no doubt you plan to appeal this.
Absolutely. We'll appeal it next week, and we'll be in the Fifth Circuit Court of Appeals, and we're very comfortable with our chances in that court.
And Dave, I got to ask you, there's another case in front of this judge. Are you concerned about that?
Well, no. I mean, as I said, Judge Cummings is a very respected jurist. We have the utmost respect for him. We're disappointed in this ruling, but we're hopeful that he'll see it our way in the other case in front of him.
And what is the other case, the plaintiff in the other case?
Well, it's the same collection of plaintiffs, and they're suing the state of Texas, which does not allow 18, 19, and 20-year-olds to carry a gun outside of their car. And again, the notion that Rebecca Jennings carrying a firearm outside of her car for her self-protection poses any risk or danger to anyone other than a criminal is preposterous. And so we very much think she's got that right, and we're fighting hard to make sure she can exercise it.